So the Colorado Freedom of Information Coalition is a nonprofit. We've been around since 1987. What we do is we educate journalists and the public in Colorado about their rights under what we call the open government laws. So that's the two public records laws in Colorado, the open meetings law, the rules that govern access to court records. I work with journalists and the public every day on these types of issues. We have a hotline, and they contact me and connect them with attorneys if we need to. We also, excuse me, we also work to try to make the laws better. So we work in the legislature with other groups. We helped open up police internal affairs records a year ago, and have done some other things like that. So just promoting government transparency is a big part of what we do. I was showing you, or trying to show you, our website, which is coloradofoic.org. If you guys want to take some time, after this talk and explore that a little bit, there's a ton on there. There's resources on there about how to write a public records request letter. There's, I aggregate stories from all around Colorado that relate to open government issues. And then I write my own stories. So I'm a former Denver Post editor and reporter. I was there for 23 years. I've been in this job for about 7 now. And I consider open government my beat. So I write about issues that affect journalists' ability to do their jobs and the public's access to records and meetings and things like that. So there's all sorts of stuff on here that is relevant to that. Yeah, I think my connection is better in this room. I should remember it in the future. So I'm going to switch over to, I'm going to stop that and switch over to a PowerPoint that I have. Okay. So yeah, if you guys, as Jake said, if you guys have questions as I go along, please put them in the chat, and then Jake can ask me, because I won't be able to see them as I'm going through. Do you see my PowerPoint now, Jake?
Yep.
Okay, good. All right. Maybe we're done with the technical difficulties. That would be good.
Knock on wood.
Yeah. So I want to talk, I'm going to have a lot of examples in here, because I think that that's a really good way of showing you the importance of these laws. And if you guys are thinking seriously about a career in journalism, you're going to want to know how to use these laws, at least to some extent, or at least the basics of it. But even if you don't go into journalism, these are laws that you could use as just a resident of Colorado or of the United States. And I want to really try to stress how important they are. So the COVID situation that we've been in for the last many months, I mean, really heightens to me the importance of these laws. I mean, just today, now we've got the President of the United States with this infection, and we're trying to figure out how bad is it with him. And I was watching the doctor's news conference, and they cited HIPAA, which is the federal medical privacy law, to say that they can't release information really about how bad, what's really going on with the president's lung scans and things like that. And I think, if we, those laws would protect, me from getting access to your medical records, but I think we all have an interest in the President of the United States' medical condition. And he I guess, can use this medical privacy law to keep his doctors from telling the public, what his situation really is. But I believe we all have a right to know that. And so, there's been a lot of stuff, very early on in this pandemic, there wasn't a whole lot of good information coming out. Part of that was due to the fact that governments really didn't know what they were dealing with yet. But, it's the job of the news media to inform the public about situations like this, and especially when something is really life and death. So this story is from the Denver Post. It's from March, after the pandemic had, started to get a little bit out of control, and it was, raging through some healthcare facilities, but the state officials were not being forthcoming about what was really going on where with nursing homes and facilities like that, even though reporters were making requests for information. And this is the type of thing that people need to know about. They need to know where these clusters are happening. The Colorado Sun, after getting very limited information from the government, just started calling around from to various healthcare facilities. Some were forthcoming with information, and some weren't. Starting to put together a picture of where people were getting sick and dying in some cases. So my organization, the Colorado Freedom of Information Coalition, actually wrote a letter to the governor that we got about 60 some news organizations and other organizations to sign, urging him to get his health department and local health departments to start releasing more and more consistent data about COVID-19 and what was really happening. And things have gotten better, but there are still some issues with that I still hear about. So, finding out or figuring out how government has responded to this pandemic is really important, especially to try to, figure out how we should act if something like this, when something like this happens again. So this is a story that Colorado Public Radio was able to do. I think this came out in June, and they had gotten emails, text messages, memos, things like that about government's response in the very early days of the pandemic, and found that there was quite a bit of confusion, really documenting a lack of preparation, things like that. These are emails between the state health department, local health departments that they were able to get. One of the, well, probably the most commonly requested public record these days are emails of government officials. It's a really important record that helps reporters tell the story of what's happening behind the scenes in government, especially when government may not be as forthcoming in what they say to the public. You probably know that government officials aren't required to talk to reporters or talk to the public, even though it's often the wise thing to do and the responsible thing to do. And the records can often show sort of things that are being said, maybe behind the scenes, that aren't being said out loud in public, that are still very important for the public to know. This is another story that the Northern Colorado Optimist up near where you guys are at CSU did about the Weld County Health Department, and how this is, I think this was in April or early May, I think, when Weld County the commissioners decided it was time to kind of open things back up again, but their own health department director was advising them not to do that. And we know that because this reporter made an open records request for these emails and was able to tell that story. And this health department director resigned, retired not too long after that. Another story that kind of is COVID related came out of public records. This is something that CBS 4 here in Denver was able to get. The reporter Brian Moss had heard that while people, hospital employees at Denver Health were being forced to take all these pay cuts and furloughs and things like that because of COVID, the executives at Denver Health were getting big bonuses at the same time. How did he know that? Well, he had gotten a tip, and then he made a public records request for the actual data that about the raises, and they gave up a lot of those after this story came out because there was a lot of outrage that resulted. So you guys probably remember, this is back in May of 2019, a couple young people shot up a school in Douglas County, and the security guard at the school actually helped save some lives, but in the process actually accidentally shot 2 people. And reporters kept asking about this. The school, for a long time, wouldn't talk about this security guard and whether the security guard was supposed to be armed. So the Colorado Sun did records requests, which we helped them with. And lo and behold, the emails and other documents showed that this security guard was not supposed to be armed at all. And in fact, the school had specifically requested from this private security agency that the guard not be armed, and the guard ended up accidentally shooting 2 students. And so what I show you this to illustrate that point, that when officials don't want to talk about something, sometimes the records will talk. And that's why it's so important to make these public records requests and to know something about how to use the laws, the open government laws, and to be able to dig into stuff especially when government officials don't want to say what happened with something. So a little bit of a civics history lesson. The whole idea that in our democracy, the importance of knowing what your government is doing, that was first articulated back, when this country was founded. And so James Madison, who is the founding father most responsible for the Constitution and the Bill of Rights, including the First Amendment, was really the founding father who articulated that the most, that for the democracy, the form of government that they were envisioning, for it to work properly, the people had to know what the government was up to. So people like me who work in this field and who celebrate these laws, and journalists, every year around James Madison's birthday, we have something called Sunshine Week. That's in March. And that's been going on for the last 20, 25 years. And we really try to focus attention, although I do this every day, we really try to focus attention on the importance of these open government laws. So happy birthday, James Madison. I didn't know this until about 2-3 years ago, but public records, were actually even mentioned in the Declaration of Independence. This was one of the grievances in the Declaration of Independence, that the king had moved the colonial meetings for safety reasons to other places from where the public records of the colonies were kept. And this was a grievance of the colonists as one of the reasons that they wanted to separate. So they could be, they thought that, this affected access to information, very similar to the point of public records laws now. So here's the First Amendment. Of course, it talks about freedom of speech and freedom of the press, but there's no explicit mention in there of access to information. And so these laws, the access to information laws are really statutory. In some states, they have them in their state constitutions, but they're really something that has been interpreted from the First Amendment, and then states and the federal government have passed laws to explicitly say that the public has access to information and needs information about what its government is doing. And this is from a Colorado Supreme Court ruling in 1983 that I think really explains the point, which is, for people to know how to vote and to help shape their views of government policy and to hold government accountable. They need information about government. It's as simple as that. And so when I'm standing in front of a class, I usually ask people if they know who these guys are. I don't know, is anybody indicating that they know who these guys are? Jake?
I don't know. Who knows who these guys are? One of them was in the news recently for not coming forth with the president knowing when he knew about the virus.
Anybody? Okay. So this is Woodward and Bernstein. I'm so old that when I was a young teenager, these guys inspired me to go into journalism in the early and mid 1970s. And both of them are still working in journalism. So Carl Bernstein, the guy on the left, is a commentator for CNN, and Bob Woodward on the right now writes books about presidents, and he just came out with his second book about Trump. I've read both of those books. And yeah, as Jake said, he had many conversations with Trump, including some from early in the pandemic where Trump told him how serious this all was. At the same time, Trump was telling the public that it was a hoax and no big deal. And so Woodward's book only came out a month or so ago, and so he got criticized a bit. Jake, have you seen the IRE conference interview with him?
No, I haven't.
I'll try to find that video because there was quite an exchange, but this was just last week. There was quite an exchange between journalists who attended the Investigative Reporters and Editors Conference with Woodward, and they didn't like how he answered their questions about that. So even though Woodward is incredible, he's the master, but he has this would be a good topic for your class. He has an explanation of why he didn't sound the alarm on that back then, and why he waited for the publication of his book. But Woodward and Bernstein would tell you that how important public records are, even though they got a lot of stuff leaked to them as well. But as journalists, the point of a good reason to use public records is that they help you get closer to the truth. You don't have to rely just on what an official says or may not say to you. Like I said before, you can get records to sometimes speak when public officials won't. And so you can be more authoritative in your reporting, be more precise by quoting records, getting records. And as a journalist, knowing something about how to use these laws really can help you stand out and get really good stories. So that's also a great reason to know something about these laws. These laws, though, are for everybody. They're not just for journalists, they're for everybody. This is the dog, the owner of the Rio Blanco Herald Times, this is her dog, and she put this picture on Facebook about a month ago. So dog is reading the Sunshine Laws guide that I wrote. So
Nice.
of course, right?
I love it. Love it.
Yeah. So as I said, these rights that you have and that I have and that all of us have to access information about our government aren't explicit in the First Amendment. They've some of them come out of court cases, but really most of them are laws that have been passed. So at the federal level, we have the FOIA, the Freedom of Information Act, which was passed by Congress in 1966. Colorado followed suit 2 years later with the Colorado Open Records Act. And then we have a Criminal Justice Records Act, which was enacted a few years later. I will talk a bit about the difference between those. There's quite a bit of difference in the presumption of access between the two. The Colorado Open Records Act covers all records of state and local government in Colorado, except for police records, criminal justice records. And then the Supreme Court of Colorado has its own rules of access to court records and the administrative records of the judicial branch. And then we have another law called the Open Meetings Law, or the Sunshine Law, that governs access to public meetings. So the Fort Collins City Council, the school board, the legislature, and it's the law that not only says you're entitled to attend these meetings, but they can only close the door on you under very, very certain circumstances. And those are violated way too often. So any questions before I go on? You can interrupt me with questions. I'm just fine with that as we go along. If not, I can dive a little bit into CORA, the Colorado Open Records Act. So CORA, we use CORA both as a noun and a verb. It's it's the CORA, the law, and then you CORA for open records. So you can think of it both ways. There's a pretty broad presumption of openness in CORA. So the main thing you need to know is you should presume that if you are doing a story on something related to government in Colorado and you want records about that, you should presume that those records will be available to you. And the only way they wouldn't be available to you is if there's something specific in CORA that either says they can't be released, or it gives the government, the records custodian, it's called, the discretion to withhold some records from you, or there's something in a judicial ruling or elsewhere in law that says the records can't be released. So when you make a request, you presume that the records will be available, and then you want them to explain to you why they're not. And they have to do that if you ask. So what is a public record? These days, it's often something digital, which makes perfect sense, but it has to be made, maintained, or kept by that government entity and for their use in in the exercise of governmental functions or involving public funds. So that's almost everything that a government entity would keep. And it could be a email, it could be an audio, a video, it could actually be a piece of paper. It's not so much of that anymore because everything is just made and kept on computers now. And there is a response time in CORA. You might have heard about people waiting months or years to get their federal FOIA answered. That doesn't happen as much in Colorado because we have a very short, theoretically a short response time in Cora, where they have to respond to you within 3 working days or less. And if they need a little bit more time, they're supposed to explain that to you, and that's outlined in the law. I have to keep drinking or else I will totally lose my voice. There is a cost. There can be a cost to obtain public records. This is a controversial thing for us because it sometimes makes public records so expensive that people can't obtain public records, and journalists and other people get kind of frustrated by this. The law is such that the first hour of what they call research and retrieval, that's what the records custodian, that's their time spent finding the records, compiling the records, sometimes reviewing them for some exception in the law that says they can't release them or they can withhold them for some reason or redact them. They can't charge for the first hour, but after that, a government entity like the City of Fort Collins or CSU can charge you up to $33.58 an hour. So you tack on a few hours to that and it gets pretty expensive. So we are very close to coming out with a paper that a University of Denver law student has done for us on this topic, because we would like to see the law changed in some ways that make it not so expensive sometimes. In my job, I hear many stories about journalists and other people who get charged hundreds or sometimes thousands of dollars for public records, and you can't spend that on every single Cora request. News organizations these days are very lean, and it's pretty rare that they can spend that type of money on getting public records. And besides, they are the public's records. It's a problem. So here's an example. Sometimes the news organization will decide to pay it. So here's a case where Colorado Politics and the Gazette down in Colorado Springs, they have the same owner. They paid $1,300 for records about how the state was responding to the COVID crisis. And they wanted to make sure that their readers knew that that's what it took to get this information. They had to pay this money for the public records. If you think about it, I mean, that's just one story. It's really can be prohibitive sometimes. I think that I don't know if I have another slide on this, but that story that I showed you a little bit earlier about Colorado Public Radio, getting all those emails and showing how the early response to COVID was very chaotic. They paid $2,000 for those records. Here's a very extreme example. I think I told you that I write about these types of issues. Well, this was somebody who came to me for help. He wanted to get records from the town clerk of Sheridan, which is a suburb of Denver, about their red light camera program. He had a very specific records request. He asked for the city clerk's emails just over the previous 7 months that contained 10 specific search terms. And they told him that would cost more than $20,000 or $20,000 to get these emails. And so he contacted me, and I tried to dig into it a little bit and try to figure out why was that the case. And it turns out the city clerk deleted everything right after she read it, and she shouldn't be doing that because some things are important to keep, and their records retention schedule of the city should dictate what she keeps and deletes. And then they were just not set up at all to archive emails. So I talked to their IT person, and he told me they would have to recreate this database one day at a time going back 7 months, and that's why it was so expensive. This guy never got his records. So even though they're public records, he never got to see them because the town just was not set up for this at all. And I don't know if they've changed anything since I wrote this story, but they should.
Would he have a lawsuit or anything against the city if he, for not making public records available in a
He could.
reasonable fashion?
I've never heard that specific issue being litigated, but it really makes you wonder, doesn't it?
Yeah, it kind of does.
Yeah, if they're just not, if the records are just not available at all, there is something in the Cora that says that they're supposed to have a records retention policy for digital records. It's just not more specific than that. And so how would a judge look at their just total inability to respond to a records request and decide that they were in violation? I don't know.
Yeah.
I don't know, what they would, how they would look at the law on that. It's certainly wrong. It's certainly not transparent.
No, it's not. But like you said, I guess it matches the letter of the law, even if it means, recreating one day at a time of a database,
Yeah, and they could argue that, well, it would cost us money to revamp our system or whatever, but the law does say that these records are open for inspection. So, how do you balance that?
Yeah.
There's got to be a way to balance that, I think. Legally, I just don't know how a judge would ever look at that. And this guy didn't pursue it. So we'll never know on that specific case. And I haven't seen another one like that. I do wonder, I do get asked questions sometimes about, can I pursue it legally because they're making it so expensive, I can't get these records. And we really haven't had a case like that either, where, is it a denial of records to just hike up the price of the records? Is that legally a denial? We haven't had a ruling like that. It would be really interesting to see what a judge would say about that.
Yeah.
So, you could run into a situation where you do get a bill or an estimate that's beyond your price range, or it seems like it's pretty exorbitant. And so I do have some strategies. The booklet, I think you still have some copies of that booklet, Jake?
Yeah, I do have some hard copies. So
yeah, I'm working on an online version of that, which I hope to have done sometime this fall. But I've got some stuff in there about how to reduce the cost of your Coras. It always helps to talk to the records custodian, see if you can narrow the request, make sure they really understand what you're looking for, be really precise as much as you can about what you're looking for, helping the records custodian find the records that you think you want. And then we've got some other ideas sometimes when all else fails. But this is actually the most frustrating question I get, because it's the law is so, it really gives the government all the power here. There's just not a lot that the requester can do. I'm working with a reporter right now for 5280, who's trying to get some mostly emails from the governor's office, and it's pretty expensive. So 5280, I think, has a lot of money, and they probably do, but they also can't spend $1,000 on every single records request. And so we're trying to figure out how to reword it. I mean, he's trying to get the person on the phone to really talk it through, and he could have a pretty good story, and he doesn't want to they want to limit it so much that he doesn't get the records he wants. So it's always kind of a tricky um, thing to do, where you want to pay the least amount, but then you also don't want to miss out on the records that would be what you really are looking for your story. So in Cora, there are these two big sections. I think I mentioned that you should presume that the records that you're interested in will be open, unless there's something in the law that either says that you can't have them or that the records custodian has discretion to withhold them from you. And so there's a list of things where they can withhold records from you if they decide it would be contrary to the public interest to release them. So for instance, CSU is doing some sort of research project and you want the records on that. They can decide, no, we don't think that would be in the public interest to release that. So that's one of those things, but they do have to have they should explain that to you, why it wouldn't be in the public interest to release those records. You'll see that one of the things at the bottom there are email addresses that people provide to government entities. Was recently dealing with a request made to a county health department in southern Colorado. They have a health department board, which is made up of citizens. And this requester wanted the email addresses of the people serving on this health department board, and they're all using their private emails. They don't have county government emails. And the county was denying that request. But this is something that they should have provided, because these people are serving on a government board. They don't have county emails, and they're doing the public's business using those emails. So I think this guy might have gotten them eventually after making those arguments, that it truly actually is in the public interest to release those, because that's how they're doing the public business. And then there's a bunch of things in Cora that says you can't release information. People with library cards, things like that, it's a private thing. You as students of a public university, if I wanted to get information on your student records, there not only is there something in state law about that, there's a federal law called FERPA that would prevent me from doing that. And then there are things like that are a little more gray and a little bit more frustrating sometimes for reporters. Records of sexual harassment complaints or investigations is one of those things. A couple of years ago, we had a lot of accusations at the state capitol, some of them involving state legislators who were being accused of sexual harassment. And because of this clause, this exception in Cora, it was very hard to get records about those complaints. This is one of those things that maybe should have some exceptions to the exception, because if you think about state legislators, their boss is the voters, and so don't the voters need to know something when there are serious, credible accusations of sexual harassment? The legislatures changed their rules a bit to be more forthcoming with some of these records now, but it's one of those things that shouldn't be as black and white as it is in the law. There's some other things in there. One of them relates to the way university presidents are chosen, and that's a kind of a controversial thing right now. The applications for non-finalists for executive positions like university president, that goes to something in both KORA and the open meetings law that talks about when the finalists for an executive position like a university president are named, how many of those need to be publicly released. And CSU and CU, when they've chosen their presidents most recently, have only named a sole finalist. So the Boulder Daily Camera sued the CU regents over this issue and won at the district court level. And that is now on appeal, but that ruling, that Court of Appeals ruling, whenever it happens, will affect CSU as well, most likely, because CSU has done this as well. So when they're searching for their president of the university, they announce finalists, but if they only announce one finalist and they only make public the job application of one finalist, that's not really how the law was intended, because it really was intended for the community to know something about how they made this decision. So there are these discretionary and mandatory exceptions in the open meetings law. One of the discretionary ones is for records. This one's kind of crazy. For records related to security procedures. This is one of those discretionary ones. It was put in after 9/11, and for reasons that you can imagine, try to protect all of our safety. And a reporter for the camera, she's now at the Denver Post, but a few years ago, she was doing a feature on Ralphie the Buffalo, the mascot at CU. And she asked for some records about Ralphie, and they denied her those records using this provision in KORA that was put in after 9/11 to protect the public safety, from, attacking the water system or the electrical grid or something like that. They use this to protect the records about the whereabouts and how Ralphie the Buffalo is kept, using that provision. So this is kind of a comical, extreme example of what governments sometimes do to withhold records. And it's just, this one was kind of, I guess they were worried about you guys at CSU, endangering Ralphie the Buffalo. Yeah.
Kenny's totally waiting for his opportunity to go steal Ralphie and take him,
Yeah.
very, frat movie prank kind of
Yeah,
thing,
maybe you could try to get the records again on Ralphie and see what happens.
I'll submit a request.
Yeah. Do it.
Yep. This is what I was just talking about, the regents violating KORA for disclosing the name and application of just one presidency finalist. That that would be an exercise for you guys. I know the Coloradoan did it and was denied. Your new president was named like a year or two ago, but you could, just as an exercise, you can make that KORA request and see how they respond. Because somewhere I have the letter that the Coloradoan received when they did make that KORA request, and they were denied, all the finalists except for the one who was actually disclosed and became the president.
Yeah, and somebody leaked it the last time. Didn't they, in the CU case?
Yeah, so there were a bunch of names that were leaked to the Colorado Independent while this was going on, but the litigation still happened, and CU lost at the district court level. So we recently did an amicus brief in this case, and we're hoping for a good ruling at the appellate level. You never know how these things are going to go, but we think it's pretty obvious. But Who knows? And here's another one I wrote on my blog about 5 years ago now, I guess. And I use this example because sometimes there are just blatantly wrong reasons that government will withhold records that have no basis in the law whatsoever. And this is an example that I encountered. I got a call one day 5 years ago now, I guess, from someone who lives in Elbert County down in southeast of Douglas County, I guess, or southeast of Denver. There's like all the counties, there's an assessment website. So that's where you would go to look up what people pay in property taxes if they own a home. How are their homes assessed for property taxes? And this person who called me said, I can look up my home and my neighbor's homes. And I know that all these county officials own homes too, but you can't find their homes on this website. And so I thought that was odd. And I ended up going down to the county and making Cora requests of their assessment records. And the assessor said, well, I'll show you mine, but I have to ask them if it's okay to give out theirs. So this was like a county commissioner and the treasurer and the sheriff, and it just, that's not how public records work. If they're public records, they're public records, and people don't have just because they're officials, they don't have the right to withhold public records about themselves. And that's what they did in this case. And I went back and I wrote a story about it for my blog, and I quoted a lawyer, and there's nothing that requires them to put them online, but in response to a Cora request, they have to be produced. And they should be produced immediately because they're available right there at the county. They eventually just put all these records online because they were wrong. And I asked the county assessor, why are you hiding these records? And she said, well, some people down here don't like us very much. And it wasn't, everybody knew where everybody lived, but she said that some of the assessment records had floor plans and things like that. And she said that somebody might want to bomb us. That's what she actually told me. Whatever.
Seems a little paranoid.
Yeah, it was a little paranoid. Some of these exceptions, there's one in particular. This one's important because if you ever cover government, write about government, you'll hear about people that are fired or they resign or something, and you want to know why. And you'll sometimes get, oh, that's a personnel record, I can't tell you. And there is something in Cora that says they can't give out personnel records, but the courts have very narrowly construed what that means. And it means that that's information of the same general nature as their home address and their home telephone number and their financial information. And it's not their performance on the job. So you still need to ask for letters of resignation and things about help emails that help explain why somebody, why was the police chief fired or the city manager, why did he suddenly resign? You need to ask for those records and don't let them claim that it's a personnel file that you can't have. So emails, which I mentioned before, are one of the most commonly requested public records now, especially by journalists, because they help you get a sense of what's going on behind the scenes, that what's not being maybe said at that county commission meeting or that city council meeting or something. You want to get a better sense of what's going on behind the scenes. And so that's why you may request emails. And so we only have sort of one major court ruling about emails. That happened several years ago when the city clerk or the county clerk of Arapahoe County was having an affair with somebody who worked for him, and the Rocky Mountain News and the Denver Post heard that there was correspondence between the two on a county. This was in the sort of the early to mid 2000s, so it was some sort of county email messaging system, and they had heard that there were actually some salacious kind of messages between the two, and they made CORA requests, and this went all the way up to the Colorado Supreme Court, which ultimately ruled that the newspapers could have the records that pertain to public business, but anything that had to do with the relationship between this county clerk and his deputy was not public business. So the salacious stuff that they were interested in, they couldn't see. But if there was some email that, you know, discussed the county budget and also discussed what they were going to do that night, it had to be redacted, and they could have that portion that discussed the county budget. The boring stuff, right? But the sort of the main thing to know about emails, you know, because a lot of people in public life think that if they use their private accounts and their private devices, they can get around this stuff, and that's not the case. If the messages have to do with public business, they are still subject to CORA. So when you make these requests, if you're making a request for a public official's emails or text messages, don't forget to ask for anything that might be sent or received using their private accounts. You know, because if they have to do with public business, they should still produce those.
And you know who will be the first to tell you that now? Hillary Clinton.
That's yeah. I mean, exactly. So, you know, I believe that you know, the original intent of having a server, a private server for her emails when she was the Secretary of State of the United States was to avoid FOIA, to avoid the federal Freedom of Information Act, and so obviously there were all sorts of other things that came out of that kind of minor scandal.
Yeah. may have swung a presidential election.
Yeah.
You know, I mean,
Yeah.
you know, so
It's like,
yeah, I mean, it was pretty significant at the time, and
yeah.
so
Yeah. So, you know, there's other things. Governments can't write agree to a settlement agreement to pay out a bunch of taxpayer money with some private entity and say, no, this will be between just us folks. You can't contract your way out of the Open Records Act. So, for instance, the Douglas County Schools a few years ago had to pay more than a couple of $1 million to the family of this student who had been sexually assaulted by a teacher, and they tried to keep this from the public, and the Denver Post found out about it, and the president of my board, who's a First Amendment lawyer, wrote a letter to the school district and got that settlement agreement made public, because they can't hide those things and say, you know, we're going to write in there that this is a confidential record. It's got to be public. Autopsy reports, if you guys ever cover crime, you're going to want to get, you know, and somebody is murdered, you are going to want to ask for the autopsy report. It's not a criminal justice record, which I'll talk about in a minute. It's a CORA record, and you're actually entitled to that. So they can't just withhold it because an investigation is ongoing. This is a recent lawsuit that we helped somebody bring against Los Angeles County for withholding an autopsy report just because the DA told the coroner to do so, and that wasn't the proper procedure. Digital public records, if they're kept in digital formats like spreadsheets and databases, because of a law we helped get passed in 2017. They have to be provided to you in those formats. This was near and dear to my heart because I spent many, many years at the Denver Post as a data journalist working with public records databases. And so sometimes governments would actually print out huge spreadsheets or provide them in static PDFs, specifically so you couldn't do any analysis on them. And so now they have to provide them that way. If you get denied and you feel like it was a wrongful denial in Colorado, your only recourse is to sue, which a lot of people are reluctant to do. If you do win, you get your court costs and reasonable attorney's fees paid. But this is something that in some other states, there's another way to go. There's an administrative appeals process in a lot of other states, or an ombudsman to go to. In Colorado, we don't have that. So it's there's not a lot of KORA lawsuits. There's a few more these days because we've got some attorneys, some more attorneys who are willing to do this, that are volunteers for us. And then actually, very recently, we applied for a pro bono attorney from the Reporters Committee for Freedom of the Press, which is a wonderful DC-based organization. We were one of 5 states chosen to get one of these attorneys to help news organizations. So this attorney, Rachel Johnson, started about a month ago, and we'll have probably more litigation as a result of that. Some tips for writing the KORA letter, and you'll see this on my website too. But a couple really important things when you write a letter to ask for records under KORA. First, you want to make sure that you ask them for an estimate. How much is this going to cost me? For those reasons that I was talking about earlier, that it can get really expensive, and you want to know, you want to get a good idea before they proceed what this is going to be. And then even more important than that is to ask that if they're going to withhold any records or redact any records from you, they need to cite something in the law that gives them that authority to do that, to withhold records from you or to redact records from you. You are entitled to an explanation of why those records are withheld. And that gives, if you still think that it was wrong or you have questions about that, that's when you can come to somebody like me and ask them that question. I should mention that you don't have to use the KORA process. Often you can just ask for public records, especially if you have something kind of straightforward and basic that you're interested in. You can start by just asking and see if you get what you want. The point of using KORA is, first of all, they are required to respond to you if you use KORA. If you state your request, according to this law, they have to respond to you. And then there's a clock that starts. They have to respond to you within a certain period of time. So if you want to make sure that you're really getting what you asked for, that they're not withholding something from you, that's when you really want to use the law. Sometimes the government entity will ask you to do a KORA request because that's just how they keep track of stuff. So if you made a KORA request of CSU, or if you just called up CSU and say, I would like a record about some report I saw or whatever, they may ask you to fill out a KORA request. But also know that that 3-day response time is only for records that are not readily available. So if there's some report that it's not on their website, but you saw some mention of it, and you want a copy of it, and it's really easy for them to get, you shouldn't have to wait 3 working days for it. And there shouldn't be a cost for something like that too, because the first hour is free. How are we doing on time?
Oh, we're good. We're good.
Okay, great.
Yeah.
Any questions before I go to criminal justice records? Anybody have anything about Cora? No? Okay. I think my voice is, yeah.
You do have some. So I know that if you go to the Student Press Law Center website, they have a great little Cora request. Well, I guess it's more of a FOIC request, but it will
Yeah.
cite Cora for you. If you are ever needing to do that, it's really handy. You just go in there and it'll basically say, like, who are you addressing the letter to? What do you want? How soon do you need it? And then it'll auto draft a letter for you. I've used that in the past. It's when I've done public record requests, it's really, really easy.
I would just make sure that if you want, it's great to use one of those things. And we've got that template on our website under resources. You might just, go back and compare the two, and those 2 elements that I mentioned, just make sure that they're in there, that you're asking for a cost estimate, and then you're also asking them to explain any denials that you get. The wording doesn't have to be exactly one way or the other, but those something like the Student Press Law Center those are great.
Yeah.
So, you got Cora, which covers all records of state and local government except for law enforcement records. And so those are covered by the Colorado Criminal Justice Records Act, which is a separate statute. And the presumption of access to records is very different. It's not as good. It's a more frustrating law in a lot of respects. We've been able to poke some holes in it recently and make it better. We and other groups that have worked in the legislature, and I'll talk a little bit about that. But that presumption that you have in Cora, where you want to, records should be open unless there's something specific that says they aren't, that doesn't exist here. So there's only a pretty small subset of records, which are called records of official action, which is really kind of a basic arrest report that have to be released within 3 working days. Most other records are sort of generally criminal justice records that could be withheld if they find that disclosure would be, quote, contrary to the public interest. So, and there's a couple of recent exceptions to that, which I'll mention, if you're covering crime and somebody's been arrested for something, that basic arrest report is really only going to give you their name and their age and, the thing that they're accused of and all that. The record that you're most interested in, if it exists, is the arrest affidavit, and that's the narrative that explains why they wanted to arrest someone. Why, it's usually the juicy stuff, the interesting thing that's going to make your story, and that is not a record of official action. And so that arrest affidavit, even though reporters often get those fairly quickly, they sometimes are withheld for quite a while if an investigation is still ongoing. So you can make a request under CCJRA, the Criminal Justice Records Act, for a criminal justice record like an arrest affidavit, and be told it would be contrary to the public interest to release this. And I hear that, and that reporters get pretty frustrated about this. So there's actually a Colorado Supreme Court case that came out of Columbine that lays out this balancing tests of interest that the agency is supposed to conduct before making that determination. So their interest in the ongoing investigation is a big factor. If there's any privacy interests, and then the public interest. is one of those factors. So when you're requesting these records, sometimes you have to keep requesting these records, because usually there's whatever you're interested in, it means there's probably a public interest in that case. And so you always want to be arguing for what the public interest is in that case. And eventually, once their investigation wraps up, it's harder for them to say, for the agency to say that they need to withhold these records, especially if it's something that the public is interested in. So this has been the case with arrest affidavits and body cam footage and things like that, and so you're always having to go back, or you're often having to go back and just keep asking for these records. Eventually, hopefully you get something. Sometimes it just doesn't happen quick enough. There's not the same response time in the Criminal Justice Records Act that there is in CORA. They don't have to produce them within 3 working days. The arrest records that you are entitled to, it's really just basic stuff. This outlines what that is. One of the things that we were able to help get changed in the Criminal Justice Records Act, and I'm hoping we can get even more changes to this, is regarding police internal affairs records. So when law enforcement officers are accused of wrongdoing, the agency conducts its own investigation of that. And if there's a police shooting, the DA gets involved, and other agencies sometimes get involved. And they do what's called an internal affairs investigation. And until this law was passed in 2019, most law enforcement agencies in Colorado did not provide these records in response to a request. The city of Denver has done it for about the last dozen years because they kept getting sued, and they just changed their policy. But practically every other agency in Colorado did not. And we know this because we teamed up with DU Law and the ACLU to do a study on this, and they made a bunch of records requests, and they got denied over and over and over again. So we got this law passed in 2019 where these records now must be made public upon request, but your request has to be pretty specific. Jake, did you see the Coloradoan stories about 3 weeks ago on this?
Yes, we did. In fact, we
Okay.
read that as part of our current events reading.
Great.
So yeah.
Good. Okay, so I worked with the reporter on that story, which he'd been working on for a long, long time, and I'd written my own commentary about this about 2 months ago or so, because this law took 2 years to get passed, and it was a lot of give and take, and what finally got passed was something that was very specific about, you had to ask for a identifiable incident of alleged misconduct involving a member of the public. Well, some agencies like Loveland, which I think the Coloradoan focused on in that story, they look at this law so narrowly that you can't, there's a lot of stuff you cannot get. And so I'm hoping that we can get, I think we've gotten some legislators interested in perhaps making these types of records even more available. I think that there's a different attitude now because of all the stuff that's been happening this year with Black Lives Matter and the protests and things like that, that maybe the timing is better to get an even better law. This one was pretty groundbreaking because these records just weren't being released at all. But I think we can get more, I'm hoping we can get a law that allows for the release of more records. If other agencies like Fort Collins and Loveland just did what Denver does and has done for the last dozen years, it would be so much better for transparency, I think.
Yeah.
And if we have things, that happen here again, like with Elijah McClain, or something happens like happened in Minneapolis with George Floyd, the public needs to know about the disciplinary histories of these officers.
Mhm.
And this law is good. It could be better, I think.
Yeah.
So another positive development, even though this won't take effect for a little bit, is the law that was passed over the summer by the legislature relating to a lot of aspects about police accountability and transparency. And one of the things it does, or it will do, is require that body cam footage and dash cam footage is released according to a timeline. So right now, and until 2023, when this provision takes effect, an agency, a police agency like Fort Collins, can say, you can make a request for body cam footage, and they can say, well, we think it would be contrary to the public interest to release this, or they might release a minute of it or something. And under the law that was passed this summer, once this provision takes effect, there will be a time limit to that. So they'll have to release unedited video and audio within 21 days. And if an agency needs more time, up to 45 days, they need to explain why that's justified. So that will be a really good change once that takes place. That's also one of the has been one of the very frustrating aspects of the Criminal Justice Records Act. I did help someone a few years ago, a woman, a mom, who was trying to get records on her son's death during an encounter with police in Colorado. And she was only provided the autopsy report. And eventually I got the records for her, but she was just denied multiple times. And the agency just said it was contrary to the public interest. I eventually got the records for her and sent them to her. She lives in Ohio. Law that's been on the books for 100 years, although it was expanded recently, that is a really good one to know about if you ever cover crime, is jail logs. We don't put people in jail in the United States anonymously. You don't just pull them off the street and you never hear about them. There's got to be a record that they're jailed. And so there's always a jail log. If you have trouble figuring out something about someone who was arrested, you always also want to check with the jail. Who's in the jail? Why are they there? There's always going to be something about that. There are cost issues with criminal justice records, just like with Cora records. It's also frustrating sometimes. There's not a set hourly cap like there is in Cora. Criminal justice agencies are allowed to assess reasonable fees not to exceed actual costs to research and redact and retrieve records. And sometimes it's very difficult to know whether it's their actual costs or not. But you need to ask about those things if you have questions about it. Same deal with challenging denials, like in Cora, you got to go to court, but there's a higher bar to prove that a denial was improper. You pretty much have to show that the records custodian abused their discretion in withholding records, and that in order to recover your court cost and attorney's fees, the withholding had to be arbitrary or capricious, which is a pretty difficult thing to prove. Um, Records of juveniles, unless they're charged in adult court, are very difficult to obtain. And as of 2017, you can't even get names and ages of juveniles who are charged with very serious crimes unless they're charged in adult court.
So kind
So-
of like a Kyle Rittenhouse kind of situation.
Yeah, I mean, that somebody like him, I'm sure, is being charged in adult court, right?
I would
But you-
think.
Yeah, but
So-
we've had, I mean, I did an article about this for my blog when that law was passed. You know, there have been plenty of 16, 17-year-olds who have been accused of very serious crimes in Colorado, and the DAs weren't thrilled with that because they want the public to know sometimes who these people are who are maybe minors but still have been accused of very serious crimes. And so that's something that, you know, the legislature had its reasons for doing. It's also another sort of balancing act, but sometimes there's reasons why someone, those names, I think, should be made public. So those are the two records laws. We can talk about the open meetings law too, but why don't we, are there any questions about the records laws? I've just imparted all the knowledge and you don't, you know.
Yeah, nobody has a question.
Nobody has a question. You know,
So,
I got to say though, if you do have questions later on, feel free to ask me. That's fine. Yeah, anytime.
well, one thing I wanted to throw out there, because I think it might be helpful for these guys if they've checked out what their class discussion is.
Mhm.
But we're going to be, but one of the things we might want to look at is how do we use public records to tell stories? And so maybe it's a good idea to maybe have a little bit of a brainstorming exercise about, you know, ways we can tell stories with public records.
Mhm.
You know, especially related to them. I mean, I know you gave them some really good ideas as far as, like, you know, making a public records request on the presidential search, the last presidential search,
Mhm.
would be a good exercise. What about something going on with the athletic department? Because currently the athletic department has been very hush hush about the investigation that's going on with them. They had stated that they were going to, you know, suspend football pending the investigation. Football is now back on and the investigation is not over, and it
Mhm.
seems like they're just not saying a whole lot.
Yeah.
So
So I think, you know, what it comes down to is, like, what are the questions you have? And about something like that or anything else involving a public entity, what are the questions you have and what questions are you not getting answers to? So that's how I would think about it. And then think about who might have those answers in record format. So, you know, just think about things like emails. It's as simple as that. Government officials will talk about things amongst themselves that they will not talk about necessarily in response to a reporter's question or even in a public meeting sometimes. So think about, you know, who might have said something to whom on email or in text message or something like that. And, you know, just figure out what you want to know and think about it that way.
okay. What about something with city budgets? Right now, the Fort Collins City Council is looking to cut about $13 million from a overall budget of around $600 million. And they have, I don't know if you saw this story in the Colorado a few weeks ago, but the budgeting process is extremely cumbersome and hard to follow for the public. But where might in the budget would an enterprising young reporter want to look to maybe see if they could find an interesting story to tell out of that budget.
Yeah, well, a lot of governments will post a lot of that stuff on their websites now. They should,
And Fort Collins does.
yeah. So I mean, I would start there. I would not start with a records request until I had a pretty good idea of what I was able to get just by going to a website, going to the City of Fort Collins's website, and poking around on there, because I think that they're probably pretty sophisticated about putting stuff out there for the public, and you know, and then see what, you know, see what don't you see on there. If you don't, if there are still questions that you have, or you don't see, you know, any kind of analysis of whatever you're interested in, you know, there could be some report about it that they put together, or you want to get the budget yourself, you know, from that website probably, or the budget proposal, and start doing your own analysis of it. A lot of those things are produced in spreadsheet or database format. And you can do your own, you know, ask your own questions of the budget on that. Another way to look at it, sometimes there are advocacy groups, civic groups that are focused on that. What are the civic groups that are keeping tabs on the City of Fort Collins budget? What are they interested in? You know, have they been asking questions about it? I bet you could find a Facebook page or something like that, you know, is some citizens group that maybe, you know, thinks that Fort Collins spends too much money, or they're not spending it on the things that they think it should be spent on. So, you know, what are those priorities? How are they analyzing things? There's lots of ways into a story like that before you make the core request, I think. Once you figure out what's not out there, then you might want to do the core request.
Okay, cool. Does anybody else have any questions for Jeff while we have him here?
Well,
otherwise, I'm going to let him move on into his next segment, but just wanted to see if anybody else had a question they want to throw out there.
All right. So we'll talk about open meetings. So the open meetings law is also called the Sunshine Law. Generically, all of these laws are called sunshine laws, but when somebody refers to the Sunshine Law, they're usually talking about the open meetings law. And this, as I mentioned, was, maybe I didn't mention, was actually initiated by the voters of Colorado in 1972. I think I had that on a slide, but maybe I didn't say it. So this is something that the people of Colorado wanted. Originally just applied to the legislature and state agencies, but eventually was extended by statute to cover all local public bodies in Colorado too. So that's cities and counties and school boards and special districts. And there's a, you know, a very strong, a strong statement at the beginning of this law, which says that it's the policy of the state that the formation of public policy is the public's business and may not be conducted in secret. That's what this law is all about. You are entitled to attend the meetings of government unless there's something specific in the law that lets them close the door. And so what is a meeting? Excuse me, I'm starting to get that.
And what's the big Q word we use with meetings, everybody? I'm going to pull some participation out of somebody here.
Yeah.
What's the big Q word that you have to have in order to have a public meeting? It's on the slide we're looking at. The fourth bullet point.
A quorum? Yeah.
Yeah. Yeah.
It's not QAnon, it's a quorum.
Two very different things.
Two very different things. So for a a meeting, for it to be a meeting under the laws, a meeting subject to the law, there has to be, as Jake said, a quorum, or for a local public body like a city council, it's got to be three or more members, or a quorum, whichever is fewer. So if two members of the Fort Collins City Council were talking about public business, any which way they wanted to talk about it, that's not a meeting. But once a third person joins that, a third member of that council joins the conversation, it's a meeting. And that meeting could be in person, or it could be electronically. They're all doing their meetings or a lot of them are doing their meetings by Zoom these days, since the pandemic started. Or it could be even by email, which actually is very problematic, because if you have three members of the Fort Collins City Council emailing one another or texting one another about some issue of city business, then that is a meeting that the public is not invited to. And they, that's a violation. So that happens. It probably happens a whole lot more than we ever know about, because in order to figure that out, you probably would have to make a Cora request for those emails. That's happened before, where reporters have figured that out. But they're not supposed to do that type of thing, because they can't invite the public to that meeting. So now, with the pandemic, we have a lot of entities meeting by teleconference. I was monitoring this stuff really closely for a while to see how governments were doing. Some of them had a lot of problems. This is Denver City Council very early on. I guess this is from early April. Lots of technical difficulties. Some public bodies had it in their rules that they couldn't have a quorum if some people were meeting remotely, and so they had to. It was weird. And they could only meet remotely during the pandemic, so they had to convene a remote meeting, which was technically not allowed, to change their rules to allow the remote meetings. So Lakewood had to do that. I was actually watching their meeting when they did that, and luckily nobody voted against it. So they're all getting better at that type of thing. The thing that I think is a problem for a lot of them still is public input, which is actually not mentioned in the open meetings law anywhere, where the public, when you go to a Fort Collins City Council meeting, they have a public comment portion that's not required by the law, but everybody does it because the public demands it. But there's not a great way on Zoom or something like that to get to really accept public comment. There's not a really good substitute for somebody getting up at a microphone and passionately, explaining their issue or their grievances to their elected officials. Someday we'll have in-person meetings again, right?
I hope so.
Yeah. So, but even if there's a meeting, it has to involve public business, but that public business has to relate to the council or the public body's policy-making powers. There's been case law about that. So the main thing to know about this is if 3 or more members of the Fort Collins City Council, they get together, they can talk about the Broncos or the Rockies or their kids, and that's just fine. But once they start talking about the business of Fort Collins, that's likely a public meeting that's subject to the open meetings law, and they shouldn't be doing it unless they can involve the public in that meeting. There's stuff in the law about, notifying the public of the meeting. It's not very specific in there about what they need to do. They just need to include specific information where possible in that notice, which for local public bodies has to be at least 24 hours in advance of the meeting. The minutes have to be taken. Doesn't say what those minutes really have to include, but that's, if they're gonna do anything at that meeting, like take action on something, or they could take action on something, they have to take minutes. And then the big thing are executive sessions. So executive sessions are when they can close the door, and on Zoom or whatever, it's when they can, turn it off to everybody else. Unless you're the Loveland City Council. Did you see that? The story from, I don't know, 2 months ago or something? They accidentally broadcast 2 executive sessions to the public. More technical difficulties.
Oh man, no, I did not see that
yeah,
one, but that makes me happy.
Yeah. So there are, the laws are pretty specific. The open meeting law is pretty specific about when and for what purpose they can tell the public to go away. This is our business now. There's some specific things in there, like personnel matters, meeting with their attorney to get specific advice on specific legal questions. But they have to announce to the public why they're going to close the door. So they have to do 3 things essentially. They have to cite the provision in the open meetings law that gives them authority to close the door. They have to give the public some idea of why they're doing it. There's got to be some specificity about why they're going to do it. We have a recent Colorado Court of Appeals ruling on this, and then they have to take a vote. And so those 3 things have to happen. And it's amazing how often I hear from people that they didn't do these things. So the Glenwood Springs City Council over the summer had a Zoom public meeting. Here it is. Yeah. They had a Zoom city council meeting, and they went into executive session. So they stopped the Zoom thing, but they didn't announce it properly. And then it turns out that when they were in executive session, they went way off topic. They didn't stick to what it was announced that they were going to talk about, which is the whole point of having that specificity in the announcement. And so it turns out that several people with some clout in and around Glenwood Springs, like the former DA, were listening to this and asked for the recording of this executive session. Usually they don't release the recording of executive sessions because they're supposed to be confidential. But Glenwood realized that they had improperly announced this executive session. They released the recording of it. Turns out they were way off topic. And so people got to listen. They got a rare opportunity to listen to an executive session. The next public meeting, this guy got up there and said, "You guys acted and sounded like a bunch of clowns."
Oh, that's great.
Yeah.
So Jeff, we're at 4:45. We wrap up at 4:50. So
okay, real quick. So stuff they can't do in executive session. They're not supposed to make any decisions during executive session. These are really common sunshine law violation: making decisions in executive session, failing to follow the proper procedures, discussing public business by email and text. I mentioned that there was an example of a reporter catching a city council doing this. This was a few years ago when a Pueblo chieftain reporter heard about members of the Pueblo City Council communicating with a county official about a garbage contract. And so he did a quorum request for their emails, and sure enough, 3 members of the Pueblo City Council were doing this, and they all got recall efforts against them. And I think 2 of them ended up resigning. So it had maybe less to do with the fact that they were violating the open meetings law than what the content of the emails showed, which got people upset. But they violated the open meetings law.
Yeah.
Not a lot of penalty in there for violating the law. A judge could release an executive session recording if you ask and they listen and they decide it was illegal. They can issue an injunction. You can get your attorney's fees if you have a successful complaint. So yeah, I guess we're right on time then. If anybody has any questions.
Yeah. Any last minute questions, gang?
So if you guys want to follow up with me on anything, I'm happy to take your question by email or something. If you are on Twitter, we're COFOIC on Twitter. We're on Facebook. I always like to keep a conversation going about these issues. Check out our website. Lots of stuff on there.